Well, joining me now to discuss the legal dilemmas facing this teenager is Dr Simon Butt. He's a senior lecturer at the Sydney Law School, and prior to joining the faculty, he worked as a consultant on the Indonesian legal system to the Australian government. Dr Butt, the Foreign Minister Kevin Rudd said a short time ago that Australian consular officials have met with the Indonesian authorities involved in this case. Step us through what this legal process that's about to unfold. What's it like?
Well, under Indonesian law, the police will begin their investigations. I'm sure they already have, including interviewing the suspect. Then within 30 days, they should make a determination as to whether they want to formally name the individual as a suspect, and collect evidence and then send the case off to the prosecution, who will then send it on to the court.
Now, you mentioned something there about 30 days. The Foreign Minister had been asked just a short time ago, how long would this teenager have to remain locked up at the Denpasar police station? Is it possible that the boy would have to remain in custody during that 30-day period while the authorities decide whether or not to charge him?
It's very common in Indonesia for suspects to remain in detention, despite Indonesian law, in my view, not requiring detention to take place. It is possible for a suspect to be released pending trial on the basis that he or she will not flee the jurisdiction, won't destroy evidence, or won't repeat the crime.
So to pick you up where you left off, 30 days they've got to decide whether or not to lay a charge?
As a maximum.
Maximum?
And given the public attention that this case has, I would expect that to be a far shorter period. Then if the police decide to pursue the case, and they may not, they may decide to drop it and let the child leave Indonesia, then they should pass the case on to prosecutors and then to the courts.
Now, the other element about this case is the boy's age, because there has been a record of Australians being caught and being charged with drug possession and other drug offences in Indonesia. This case is different because it involves a 14-year-old. The Minister says that he is sleeping alone in a cell and that his dad is allowed to sleep in an office next to the cell. But there has been a lot of conjecture about the Indonesian legal system and how they treat people who are underage minors. What can you tell us about the treatment of minors in Indonesian system?
We have to keep in mind that Indonesia is a developing country, and despite its laws saying that children should be kept separate from the adult population, for example, should be treated in a non-confrontational way, if possible, in the courts. Sometimes it's harder to do that in practice, and so, for example, UNICEF estimates that about 90% of Indonesian children in jail have to spend time with adults. So sadly, this idea of juvenile detention, although on the books, in practice has been hard to implement with limited money.
The other issue is the various penalties that this boy may face if he is found guilty of this charge, and he hasn't yet been charged. He had, we're told, almost 7 grams of marijuana. What are the various penalties that are possible for a possession charge like that?
I've heard in the media, figures like 12 years in jail. Personally, I think that's highly unlikely. For one, that's the penalty for people involved in selling and possessing larger amounts of marijuana. For users, or misusers as the term is in the Indonesian narcotics law, the maximum term is 4 years. Now, one thing that's important to note is that children under Indonesian law, that is under 18, get half the maximum penalty of an adult. So automatically the maximum penalty would be 2 years. And I would think that there'd be many circumstances that an Indonesian court would take into account, like age, politeness during trial, first offence if that's the case, and the like, in order to reduce it even further. So I think a matter of months would be anything if indeed a prison term occurs. And just the possibility of the defendant being released by a judge is also real under the child justice law. judges can simply allow children to go back to their parents, even if they're found guilty.
And finally, Dr. Butt, there's already been massive publicity naturally here in Australia about this case. The Foreign Minister cautioning Australians not to try to put too much pressure on Indonesian authorities. I mean, how difficult is it? I mean, do the Indonesian authorities respond badly if they feel that there's too much pressure coming from another country, or would they be understanding that there is naturally a high interest in this case?
I think they'd be understanding that there's be a high interest in this case. The same would occur, or has occurred, when Indonesians have been in jail in Australia. But I think that the idea that the system, the process might be somehow helped along with prodding and pushing doesn't really help very much. The Indonesian system is independent, and there's some things that consulate officials can do, but really the process needs to take its course.
Perhaps why the Foreign Minister was urging everyone to be patient. Dr. Butt, thank you very much for joining us this afternoon. Appreciate it.